of people, the officials have conflict. I so rule. Please, if you move any of this issue, I will rule you out of order, please. I so rule. Mr. Chairman,
to the referral. The referral is very clear that we should investigate the issue of monopoly, not the issue of the issue of license and all. Having said that, Mr. Chairman, I think that I am in tandem with the presentation of the chairman of the BL, the BL. The fact is that when it gives monopoly, it does not do any good to any society. The NCC should be able to issue license as many as any collecting society that meets the requirements. I will also say, Mr. Chairman, that they should go out of their requirements and issue licenses. Anything illegal is illegal. I will not condone it. But I think that the issue of monopoly is bad for the society and it must be broken. If we have to do it by amending the law, the act that established NCC, Mr. Chairman, we should do it in haste. Thank you, Mr. Chairman.
Suggest to NCC that where an organization applies and it falls short of certain requirements, I think it is their duty to advise them to meet up the requirement. They are largely advisory. If I go to CAC today to register a company, if I have problem, they should tell me, you have not met this, you have not met this, go and amend this, go and get a good lawyer to help you, and then come back for registration. I think that's how it should be, Mr. Chairman.
A rider to the submission made by my chairman, House Committee on Information. I'm also surprised because we are talking about what will happen after oil in terms of capturing our revenue. Today we talk about not being able to implement budget 100%. Reason being that we do not have sufficient funds to fund our budget. So for the DG, I would be expecting, or I would have expected, that he should also add value by ensuring that his agency form part of the body that will be contributing to our internally generated revenue. By ensuring that his agency will pride itself to say, I have registered this much, I have collected this much based on that, and these were what were accrued to us. We will nil off our administrative charges, and this is what we have paid into consolidated revenue. That should be the key thing for any body or any person who wants the economic growth of this nation. And I think that should be upheld, that we should not only think of oil, but we should think of other areas that we can use to capture our revenue. And that had been highlighted in the motion that we're losing funds. Imagine if 100 billion, Mr. Chairman, is injected in addition to other revenues. We'll be using it to nil off some of the critical infrastructure that will make life meaningful to our people that have voted us into office. So I think we, as true representative of Nigerians, should look into that and remove this aspect of monopoly that you are here to address. This is my candid, and as we're here, let the DG be thinking. They don't have anything personal. So if there's nothing personal, and you're a father everybody, and don't discriminate, because that kills homes, it brings bad blood, and people begin to poison their fellow brothers or sisters, and they begin to fight. So take everybody, but put a criteria that will enable them to also come up. And the issue of adequacy, where there are many players in the industry, and all of them are not trying to admit, allowed to be admitted into one body, it means there is no longer adequacy as provided in the law establishing NCC. I so submit.
Thank you very much. We give them, we clothe them with the law to function for the government of this country. So we have not even come to the two societies and the general public. We want to be sure that NCC is playing by that rules, and that even if its law is not adequate. Now, hold on, I'm talking, let me finish. if NCC if the law is a problem for NCC, we need to strengthen it to do its job, and we will so do. NCC will come back to you, but I'm coming to you. But before I do that, I just wanted to make sure that is there anybody from the Office of the Attorney General? Yes.
I was actually this morning and he's indisposed, so he's not here today.
Mr. Gigi, do you have the authority that he asked you to deliver an oral apology to the committee, Parliament committee, a joint committee for that matter, a committee that has consistently invited the Attorney General, and the Attorney General has neither acknowledged nor attended nor sent a representation? At this point, are you saying that he sent you with an oral mission of apology?
Yes, that's exactly what I'm saying, Mr. Chairman, because I did go...
And is it proper for Attorney General of the Federation to pass an apology in a matter that involves him personally? This is a matter that the Attorney General is not only a nominal party. This is a matter that the Attorney General has, and creditably, he has done a lot to bring the two parties on the table, and the Committee on Justice and the Committee on Judiciary has invited him to come and tell us his intervention, because we want to resolve this as legislatively as we can. Now the Attorney General has chosen, as usual, not to attend, not to send a representation, not to contact the committee in any way whatsoever, but will rely on to send a DG by an oral apology, and that apology even not forthcoming until the issue of the Honorable Attorney General's presence was raised by the chairman. I have the authority of my members that unless the Attorney General appears in person on Tuesday, the 4th of June 2013, this Committee on Justice and Committee on Judiciary, we have no option, we'll be left with no option but to issue a warrant of arrest, regrettably, for the Attorney General. I so rule. DG.
The Attorney General actually arrived in his absence. Yes, that's okay.
Matters for you that a society must, that your rules or regulations specify for approval, and then what has MCSN have not done, so that we know factually those two issues.
Can I invite a member of my team to take that, or would you want me to? I'm happy to take it. Yeah, sure. Okay, I'll take it. The High Priest actually made that quite clear when he gave his submission. The conditions for that must be satisfied by any organization wishing to apply for approval as a collecting society. Section 39, subsection 2 makes it quite clear that it must be an organization incorporated as a company limited by guarantee. Its objects limited by guarantee. 2, its objects are to carry out the general duty of negotiating and granting copyright licenses and collecting royalties on behalf of copyright owners and distributing same to them. 3, it represents a substantial number of owners of copyright in any category of work protected under this Act. Substantial, that's what the law says. Yeah, but I'm not in a position to interpret the law. That's a matter for the courts. Also, it complies with the terms and conditions prescribed by regulation made by the Commission under this section. And those terms and conditions are clearly stated in the Copyright Collective Management Organizations Regulations 2007. No. Can I just point out that under the Copyright Act,
Please,
the Commission, the Commission...
I'm protecting you.
Yes, yeah, thank you very much, Mr. Chair. Under the Copyright Act, the Commission has powers to make regulations, and one of those regulations is the Collective Management Organization Regulation 2007, which it says the terms and every company applying for license to operate as a collective management organization shall furnish the Commission with the following documents: a certificate of registration in respect of the company issued under the Companies and Allied Matters Act, the Memorandum of Association of the company, the Articles of Association of the company, a statement indicating the class of right or category of right owners in which the society owns rights or intends to represent or act. 4, membership list of not less than 100 right owners representing the classes of right to which the company is seeking a license to operate as a collective management organization, which list shall indicate the signed consent of such persons to belong to the organization, or where the organization has been in existence, that they are members of the organization as set out in the schedule to these regulations.